Hello everyone and welcome to the VivaVisa Podcast by Adhami Law Group, your go-to resource for navigating the U.S. immigration system. I'm your host, Amir Said, here with attorney Kousha Adhami. In this episode, we're breaking down some of the biggest questions around seeking asylum and the court process, like how long you might wait for a hearing, or whether you can work while your case is pending, and ways to reduce time in detention. If you have ever asked, can I get released on bond, or what exactly is parole, then this is the episode for you. Listen in as we clarify the steps you need to take and share practical tips to help you and your loved ones pursue a secure future in the United States. Now, let's get started. Hi, Kousha.
Hey, Amir. Thank you for having me.
Thanks for joining us. Okay, let's start with this question. How long does it normally take to get a hearing date before an immigration judge?
Oh, okay. So it's a little complex, but I'm assuming that this question is related to asylum seekers. So, an applicant is placed in removal proceedings when they're issued a notice to appear. A notice to appear is issued when either first the applicant has presented him or herself at the port of entry and they are seeking defensive asylum, and that is after their credible fear interview has been positive, so they're issued a notice to appear. The second scenario where an applicant is placed in immigration court and a notice to appear is issued is when the asylum office has determined that their asylum case was denied and they're referred to immigration court. The third category, I would say, would be the miscellaneous category. That is if the applicant has been living in the U.S. and they encountered a criminal conviction, or they applied for other reliefs with USCIS and they were sent to immigration court. Okay, so assuming one of this stuff happened or any other scenarios where the applicant is placed in immigration court or removal proceedings, a notice to appear is issued. So when a notice to appear is issued, then the jurisdiction of the applicant's case is with immigration court, or also known as EOIR. So there are different type of hearings, and we have a master calendar hearing and individual hearing. Ordinarily, when a notice to appear is issued and respondent or applicant is ordered to appear in front of the immigration judge, the first hearing are usually master calendar hearing. At the master calendar hearing, the immigration judge will want to review the notice to appear and determine what type of relief the applicant is qualified to apply for. So, for example, they're are applying for asylum, they're applying for cancellation of removal, adjustment of status, SIGIS, all these other reliefs that are available before the immigration judge. Once the master calendar is done, depending on the applicant's case, an individual hearing is set. When the individual hearing is the same as having a trial. Basically, at the individual hearing, the judge will determine whether the applicant should stay in the U.S. or not, and whether a deportation order will be issued, a green card will be issued, or removal proceeding will be terminated. So in terms of its time period, I cannot say exactly the time period, but usually, a few months after the notice to appear is issued, the immigration court will schedule a hearing for the respondent. I think I answered the listeners' questions, right?
Right.
Yeah, or I went a little more in detail, but I think that it's important for our listeners to know the process that will take once they are placed in immigration court.
Right.
Or removal
Exactly.
proceedings, yes.
Right. And, usually we cannot come up with an exact date because it's not just about one case. Lots of cases.
Right. And based on the administration, how they how they're handling the case dockets and all that.
Right. The other question that comes to my mind and I want to ask you is that can asylum seeker work in the United States or apply for work permission while waiting for the asylum?
Yes, that's a question I get a lot too. So, if you are in immigration court, in order to apply for your work authorization, your asylum application has to be pending at least 180 days. So that means that there is an asylum clock, and your asylum application has to have been pending for at least 180 days before you can apply it with the asylum clock. Now, if you're applying, if you have an affirmative asylum case, it's the same thing. Your asylum application has to be pending at least 180 days before you can apply. There are other things or scenarios that can stop the clock. So if you don't show up to your hearing, or if you don't show up to your interview, if you file a motion to change venue, motion for continuance, or any other stuff could stop the clock. The clock is very sensitive. So if you want to get your initial work permit and hopefully renew it further on, you have to be wary of how the clock works.
Gotcha. Kousha, how long does an asylum seeker remain in immigration at detention? And could an attorney help to reduce this time?
Okay. All right. I'm going to try to answer this question the best way possible. So it depends. It depends on the applicant or the relief that they're applying for. But ordinarily, when a notice to appear is issued and respondent is placed in immigration court, they can seek to be released from detention in various different ways. First one, if the NTA is issued and respondent and the immigration court has jurisdiction over the respondent, then they can respondent can request a bond. Basically, at the bond hearing, the respondent has to show that they're not a danger to the community and they don't have a risk of flight. Basically, you're gonna show up to your court hearing and you're not gonna be a danger to the community. Based on that determination, the immigration judge can set the bond amount and release the respondent. There are different type of bonds. There's a Rodriguez bond, and that has been litigated. I think there's only in one area of Central California where you can request Rodriguez bonds. And that's after if the respondent had been detained for more than 6 months, they would get an automatic Rodriguez bond. Okay. In regards to, there are other ways where the applicant can request to be released from detention. That's if USCIS or Department of Homeland Security has jurisdiction over the respondent, then they can request for parole. Basically, when you request for parole, you're requesting to be released on the basis that, on the criteria that is set by Department of Homeland Security and USCIS, and you also still have to show that you're not a flight risk and danger to the community. The difference is that when you're seeking to be released on parole, you're making that request from USCIS or ICE. The alternative is the previous one, you're requesting to be released from detention based on the determination of the bond hearing of an immigration judge. So when your bond or parole is requested, depending on the applicant's case, if they have like criminal history or they have prior immigration violations, their bond can be set anywhere from $1,000 to tens of $1,000s. So it depends. Or they can be released on their own recognizance. Sometimes they release them and they have like an anchor bracelet and they have to continuously check in with ISAP.
Okay. Kousha, you mentioned and talk about parole. What does it mean?
Okay. So it's a very, very complex area of the immigration law. So the purpose of parole, or the purpose of a humanitarian parole, is to allow an otherwise inadmissible individual to enter the U.S. for a temporary period of time due to some sort of urgent humanitarian reasons or for significant public benefit. So to kind of give you an example, after the Ukrainian crisis, a lot of Ukrainians were allowed to seek parole into the U.S., and that would be based on humanitarian reasons, okay? Or it could be a significant public benefit, but in this case, I would say it would be based on humanitarian reasons. So they're seeking to stay in the U.S. temporarily because they're unable to live into their country. Now, parole can be very, very complex because it has different categories, and you can be paroled under different classification. So an asylum seeker who present him or herself at a port of entry can be paroled into the U.S. and be deemed as an arriving alien. Okay, so when you're paroled into the U.S., you're not admitted. Okay, because the definition of admission and inspection for a person of immigration is different than parole. But you do have a legal entry. Okay, so when someone is paroled into the U.S., they can use that classification to apply for certain other immigration reliefs. Like, for example, if someone is an arriving alien, okay, and they enter the U.S., they were paroled into the U.S., okay, and while their asylum case is pending, they marry someone who is a U.S. citizen, they don't have to leave the country because they were paroled into the U.S. and they can apply for their green card in the U.S. as a parolee. So it makes a huge difference because that's a classification that ICE or Customs Border Patrol is making upon the respondent's entry. So there are also different types of parole based on the status of the applicant. So, for example, DACA applicants can seek advanced parole based on humanitarian reasons or other like significant public benefit. VivaVisa applicants can do it as well. TPS applicants can also seek parole, advanced parole, or parole. Basically, like for example, for TPS and DACA applicants who are seeking advanced parole, they live in the U.S. Under their temporary status, and they are seeking to go out of the country for a short period of time and come back in. Okay. So as I mentioned, so there's various categories of classification of applicants that can request to be paroled. So someone who you can apply for adjustment of status as be paroled. So basically, while your adjustment of status application is pending, you can seek advanced parole. You can apply for your green card on the Parole in Place program. That's when you have a military relative who is seeking to petition you and requesting that you don't leave the country for adjustment of status. And also, going back to our main thing that we talk about regarding this podcast is actually CJIS applicants. CJIS applicants, even though they entered the U.S. illegally, once they have their I-360 approved, they're able to apply for their adjustment of status in the U.S. because they're considered to be paroled in. So I hope I didn't confuse my listeners, but having so you can be paroled at the port of entry upon your entry, or you can request to be paroled when you're outside the U.S., or you can request to have an advanced parole when you're in the U.S. So it's a little complicated.
I guess we have to have some episodes about one of those parole that you talk about it, right?
I guess so.
Yeah.
Yes.
For the last question, Kousha, what are alternatives to detention?
Okay. It's kind of, the question is a little general, but I'm assuming that the listeners are asking if someone is detained, what are alternative ways of helping this individual to obtain a legal status or continue his or her case. Okay. So if, I'll give an example because I used to do a lot of bond hearings or detainees. So I had a client, Iranian, he entered the U.S. Illegally, presented himself at the port of entry. He was seeking asylum on the basis of religion, right? So he was detained, okay? When they were placing him in detention, the immigration judge expedites this case because it's very expensive for the respondents or applicants to be detained, because you have to keep him in detention, feed them, and it's the housing and everything. It's very expensive. So they expedite the case so they can have their individual hearing or their asylum case and all that. Now, what I did in this case, and that's, I think, a proper way of going about, because you don't want to keep your client detained for a very long time. They lose their mind. Okay. So the best way is to seek bond hearing and release them from detention. And why would you do that? You would do that because, number one, you have more access to your client. Number two, your client is going to have more access to resources. Number three, your client is in a much better state of mind to cooperate with you in presenting his case or her case before the immigration judge. Okay. And number four, when once you're released from detention, you go on a non-detainee docket with the immigration court. And in that case, your case is not going to be expedited. That means you're going to have much more time, and you need more time to prepare your case for your master calendar hearing or individual hearing. So, that's exactly what happened to my client. We were able to get him a bond hearing. The immigration judge granted his bond. He was released. We had his asylum case heard before immigration judge in downtown LA, and the judge granted his case. And before granting asylum, he got his work permit, and now he's a green card holder. I think he should be applying for citizenship right now. I don't remember that. It's too many of them to keep track of. But to answer the question, alternative to detention is to get released from detention and have your case be heard before an immigration judge in a non-detainee docket. Now, if that doesn't work out, full speed, you got to go forward and present your case before the immigration judge in detention while your client is detained, and the judge will make the decision based on that.
Got you. Thank you. Thank you, Kousha. It was great. I learned a lot. And I hope our listeners could learn a lot from you. Is there anything that you want to add?
Yes, I would just say, if you have someone who is detained, make sure to reach out to an attorney to get them out, because, that environment can be very difficult for applicants or respondents who are detained there. And the best way for them to be able to help themselves is if when they're released from detention. Because most of them are not criminals, who are detained. These are people who are just seeking asylum and who've had difficulty in their own countries. But you do have people who also have criminal records who are in detention facilities. But it's easier. It's just much better not to be detained while you have your case, outside.
Perfect. Okay, Kousha, thanks for joining us, and I want to say thank you to our listeners. I hope you enjoyed and learned from today's episode. Make sure to check out the show notes with the description for access to our website. Also, make sure to share this episode with your friends and subscribe wherever you listen to your podcast. We really appreciate hearing feedback from you, so please share a review for this episode or check out our website and ask your questions. We are located in 21031 Ventura Boulevard, suite number 760 Woodland Hills, California 91364. You can also call us at 213-204-6500. Until the next episode, take care and bye.